Davenport paid a former city administrator $1.6 million
Yes.
without public input in 2023 to avoid a sexual harassment lawsuit. That decision has drawn its own lawsuits against the city from residents, which are still ongoing. It prompted a hearing before a state legislative oversight committee, and it's generally degraded public trust. What can the mayor do to restore that trust?
First of all, we have to start complying with the open meetings law. The state legislature almost unanimously pointed directly at Davenport for violations of open meeting laws. There were decisions that were made even behind city council, including me, council members, that related to those payouts. That cannot happen again. I was not involved. I was kept out of it, and you cannot make decisions in an executive session, and therefore we need to keep bringing council forward, making their deliberations more public, getting more information to the city council, early and accurate, not 5 o'clock on Friday, and make it to where all these open sessions to help make these deliberations are available online and you can come watch. So no more backroom deals, no more hiding information.
Thank you, Mr. Gordon. The question is, what can the mayor do to restore trust in the fallout of that?
This is a great question, and it's one that I think my candidate perhaps has some challenges with. There's only one mayoral candidate that was in the room on October 4th in a closed session where those discussions about the settlement payments to the former staffers was considered and approved according to a judge, and that is my opponent. We know that a judge reviewed the audio from that October 4th closed session and ruled that all those that were present assented to agreeing to move forward with those settlement agreements with the now departed separated employees. We also know that the judge further ruled that what happened in open session 2 months later in December was a ratification of what had already been approved in October, not an approval. In other words, the decisions had already been made in closed session, and we know that my opponent was in that room on October 4th. So I think this is an issue that she perhaps has some challenges with.
I would like to respond.
Please.
I do not have any challenges with those. I testified in court, sworn. I have an affidavit. It is illegal to make decisions. The decisions were not made. I agreed to further negotiation. I never even knew there was a demand letter until I walked in that room. I never saw it, and I never saw the agreement until it came out 300 days later in a court case and based on subpoena. So I was also not involved with the ratification of that decision.